Good morning all, and welcome to another of our monthly CPD series. This time it's a little bit different, but still very relevant to all sectors. It's all about the risks of being an expert witness. I am your host, Andy Ferguson, and today I am pleased to welcome Dr. Paul Beckett from Florida. Morning, Paul.
Morning, Andy. Morning, everyone.
How are you, good sir, this morning?
Yeah, good. Weather's a bit rubbish, but pretty good.
Well, folks, anyone that's been tuning into our webinars on a fairly regular basis, again, and as always, a big hello to you. If you are a new listener, a big welcome to you, and we do really hope you get some valued learning from today, and also as well that you enjoy the chat. I just want to point out to folks that over the course of the webinar, if you do have any questions that you want to pose at any particular time, there's several ways in which you can pose those questions. Firstly, if I can point you over to the chat facility. Now, if you're on the desktop, that should just be on the left or the right-hand side of you. Simply just click on chat and basically kind of punch away. If you're on the now, why don't you come on and say a wee hello to us? If you're on the mobile, it'll just be slightly at the below the screen. All you just need to do is pull up on your mobile a little bit and you'll see the chat functionality in there. Alternatively, you can ping any questions to me via email simply at andy@property-care.org. That's andy@property-care.org. Or if you are so socially savvy, you can go on via our social media channels and ping your questions via that way. All you really need to do is use the native search tools within these social media platforms, either on Twitter, Facebook, or LinkedIn, and just contact me via that way. Just also to let you know that if over the course of the webinar, if for some reason that there's some issues with the streaming, it does happen. It is 9 o'clock in the morning. Everyone's turning on their PCs. If it does come up and it's crashing, there should be a button that comes up on your screen that allows you just to basically refresh and rejoin. Now, anyone, if you see anyone over the chat and anyone's mentioning that the streaming issues, if I'm not quick enough to get there, if you can just basically just ping a wee message and say, guys, just refresh the screen and it will be all hunky-dory. That would be fabby. I also just want to throw out there as well that in terms of future webinars coming up, we're very interested to hear what you guys would like to hear about. I mean, what is it you guys are interested in? If you can, let us know. Either jump onto the chat facility there and stick it in, just what you would like to hear from or learn about. Or again, alternatively, you can email me at andy@property-care.org and we can see what we can do. Paul, I can see we've got a couple of minutes. Just before we kind of start, as always, I always like to do a little bit of tinkering and try and find out about guests that are coming on, and those that are listened in will know I like going all about social media and trying kind of digging. But I learned something about you quite recently. I actually learned you're actually really a Scotsman. In fact, not only are you a Scotsman, you're actually pretty much born right next door to me. We're both West of Scotland laddies.
Yeah, and proud.
I'm proud. I mean, just for those guys that don't know West of Scotland, that's areas just kind of west of Glasgow, so it's down like Ayrsham, Rann, etc. It's typically known as banjo country because we're all a wee bit backwards. I mean, I'm probably slagging myself off and being derogative here. But I'll tell you what else I was doing as well, Paul. Like, just because I got a couple of minutes here, as I was mentioning, I always like getting socially savvy, and I was on trying to check out and find any juicy gossip about you, and I have to say, I'm pretty disappointed. By all accounts, you're a saint online, but I will tell you this, though, I did trip across something about you, and I was quite really pleased to see it. I did notice you've knocked together a couple of videos quite recently. What was it? The good, the bad, and the fugly, was it? Is that right?
That's right, yeah. Yeah, the freaking ugly, if you wonder what fugly is.
The freaking ugly. Well, it's great to see you guys kind of embracing that. And you know, folks, if you've not kind of seen it, if you trip over to Paul's Twitter feed, you'll be able to catch up on them. But folks, I can see there's a stack of people that's just joined us. Big welcome to you to our next in our CPD series. This time it's all about the risks of being an expert witness. We are about to start the main presentation. Just for those that have just started, in case you want to pose any questions over the course of the webinar, I can just point you over to the chat facility on the desktop. It's just on the left and the right hand side. And a mobile, you just need to pull up and you'll find it in there. Please feel free to say a wee hello to us. As I said, any questions over the course of the webinar, just feel free just to pose it. Well, Paul, I can see successfully 9 o'clock. So, Paul, the risks of being an expert witness. Now, I know from chatting to you and also taking a wee crash course of online learning that being an expert witness is no easy. So I suppose no matter what sector you are from, when disputes erupt, who is actually right for the job? What are the challenges and what are the risks and liabilities does it potentially carry? Big questions, Paul. Over to yourself, good sir.
Yeah, well, hopefully we'll find some answers to those in this webinar. So thanks for the introduction and for embarrassing me. So let's crack on. What is the purpose of this webinar and who's it for? This webinar is based on my personal experience of expert witness work. And I've done a fair bit, so I hope you can learn from it. It's a broad overview, really, of what's involved in being an expert witness. I'm focusing on civil claims, so litigation, damages, because this is really what most PCA members will be getting involved in. Technical people getting involved in disputes where people have suffered loss. Despite what Andy has hinted at, possibly, the intention is not to put people off from getting into expert witness work, although that might be a consequence. I don't know. Really, I want to open technical people's, consultants, contractors' eyes to what is required of an expert witness, because it is quite a specific thing, really. It's quite different to the normal technical work and reports you might be producing as a technically proficient contractor or consultant. I'm aiming quite low. I'm aiming really at people who have little or no experience of expert witness work, and who might be interested in becoming who might be interested in becoming an expert witness. And I see we've got quite a broad audience from people from different technical areas and also some people from the legal profession. So that's what really I'm pitching at, is really at the technical people with limited experience of doing this sort of work. So a little bit about me. So what the hell gives me the right to tell you anything? I don't pretend to know everything, that's for sure. I'm not the most experienced or most knowledgeable expert witness. I admit that. But and like many technical consultants doing expert witness work, it's not or it hasn't been a huge part of my job. Mostly I'm doing consultancy technical work for clients, and expert witness work is just a small part of that. However, for various reasons, it has become a significantly more important part of my work in the last few years, really. Although I have been doing expert witness work for quite a while. So academically, I am a plant ecophysiologist, focusing on plants and their interaction with air pollution. And I started my employment as an environmental consultant, principally modelling and monitoring air pollution. And it's through that job that I was introduced to expert witness work. And my employer put me on a course 20 years ago now to be trained into giving expert evidence. I cut my teeth really on public inquiry work, which is quite different to the court-based litigation stuff that I'm mostly doing now. So that's expert witness input to large planning applications that go to public inquiry. It's quite a different environment there. You've got because you've got huge teams of consultants, They're big development projects. You've got a lot of people in the audience, third parties, who are interested in it because it affects a large area. You tend to get QCs as the barristers, so that's Queen's Counsel. They're like the top level barristers who really know their stuff, and it's quite an adversarial environment. So it's probably actually quite a good environment for me to learn the environment of the adversarial environment of being between two arguing barristers. So that's really where I started. But I really got into, as I focused on knotweed work and consultancy, I got a bit more involved in litigation, and that culminated in a landmark case that some of the knotweed people might have heard of, Williams and Wastall versus Network Rail, a number of years ago. That was a precedent-setting landmark case, and that has really opened the floodgates. So in the last few years, I've been doing a lot of litigation work for defendants, for claimants, and as single joint expert. So that's really where my experience comes from. As I say, I don't pretend to know everything. I don't have the huge experience that you might see some medical expert witnesses who do an awful lot of work and probably just do that sort of work. But I hopefully, for the audience I'm trying to talk to here, hopefully I've got some insights that you're going to find useful. Right, hand over to Andy now. This is Andy's poll questions. Are you going to jump in, Andy?
Sure. Well, here, folks. We're just interested in having a wee nosy here. I'm just going to basically throw a wee poll question here, which is, who in a webinar here has actually been an expert witness? Now, poll question. Oh, I thought I'd published it, but I've not. My apologies here. There we go. I've just published it now. It should hopefully have just popped it up on your screen. And we're just intrigued to find out if you've been an expert witness. Well, hit option 1. If you've not, then hit option 2. I can see the results coming in. I'm not going to. There's clearly the largest majority is no, just at the moment in time, Paul. Folks, just to give you, we got another couple of seconds, another 5 seconds or so, just to answer. 5, 4, 3, 2, 1, and there we go. I'm just going to end that. But Paul, I'm unsure if you can see the results there, but 25% of our audience has actually been an expert witness, but the large majority of it haven't, at 75%. Okay,
well, that's interesting. So hopefully the majority of you, at least, should come away with something useful from this. So who and what is an expert witness? Oh, hang on, I've gone a bit too far. Who and what is an expert witness? So it's simply someone with the technical experience and knowledge to help the court understand a particular technical matter during proceedings. The role and the duties have been focused about 20 years ago when the civil procedure rules were put in place. Now, the reason they were put in place was that the judiciary realised that many expert witnesses going into court really didn't know what they were doing, didn't understand their duties, and they weren't really fit for purpose. So, or that's just one part of the civil procedure rules, but that was one of the main reasons for formulating all that guidance, those rules rather. And I'll come on to the section that's useful to expert witnesses, but that really lays out what you need to do. Nevertheless, there are still a lot of experts out there who are not up to the job really, and that causes all sorts of problems, which I'll come into. Just because you're technically proficient at what you do doesn't mean that you can just jump straight into being an expert witness. And in some of the examples I'll go into of where people have been sanctioned, experts have been sanctioned for not doing a good job. A lot of it has come down to the fact they just didn't realise that their duty is different to the normal duty you might have to a client who you're producing a technical report for. Another thing that the reason why there's a lot of experts out there who aren't really up to the job and are probably out of their depth is that the general thrust of the cut and thrust of the litigation industry means that most in fact claims settle before you even get to court. And it's in court really where an expert witness's mettle is tested. So you could do a lot of expert witness work but never end up in court. So you never really know if you're doing a good job or not, because nobody sees your work, because it's all part of the discussions between solicitors that don't get disclosed beyond them because there's a settlement. So the next bit I'm going to go on, these are just some quotes, really. I've just pulled up some sound bites from important people that I've come across in my career journey as an expert witness. So this was a QC barrister, so a high-ranking barrister during a public inquiry that I was at, and I think he was saying this to me to really humanise the enemy, humanise the barrister, the QC on the other side, because barristers can be quite scary people, and these are the people that really are, they run the show when you're in court. So the technical information you produce, really the audience at the end of the day is the judge. That's who you're writing for, really. But the veracity is checked by barristers. Your mettle and how solid your opinion and your evidence is tested by barristers, particularly during cross-examination, where they really can be quite make you feel quite uncomfortable in the courtroom. So they're really the players, and that's really, if you can't stand up to a barrister, then you really shouldn't be doing expert witness work. But this was an attempt, really, from a barrister, and it's true. Although I'm always impressed at these guys, these barristers. They're super bright people. They're very good at their jobs. If they weren't good at their jobs, they wouldn't get any work. QCs are the best of the best, and their ability to absorb a lot of technical information and to focus on the pertinent issue it is amazing. But saying that, really, what all they are elite level arguers. But that's quite a daunting thing in itself, I suppose. Having to convince someone or fend yourself off from somebody who's very good at arguing and putting you down. If you end up in court, you failed. Glib statement, but it's sort of true. This was said to me by a building surveyor expert witness who's got a lot of experience, and he said this to me quite early on when I was really just starting to get into courtroom litigation stuff. It's sort of true because as an expert, you're facing an expert on the other side, and you're challenging each other's evidence. But if you both know your stuff, you ought to be able to agree. If there's a big discrepancy between what you say and what the other side's expert says, then there's something's not right. So if you manage to agree everything with the other side's expert, you don't end up in court. So if there's where disagreement remains, that's when you end up in court. So in many ways, if you do end up in court, then you perhaps haven't done your job so well. It's not quite true, but certainly it's quite rare in a case to end up in court. You'd hope anyway, if you're a good expert. So that was quite a useful soundbite from somebody who knows what they're talking about. This is another one from a judge at a networking event I was at. Lawyers don't give feedback, particularly praise. This highlights the fact that us experts don't get an awful lot of guidance on the work that we do. And that's quite daunting, because really you've got to learn through experience. And learning through experience in the cut and thrust of a litigation trial is quite risky. It's quite a daunting environment, and I think what this judge was explaining to me, I was saying to him, look, I never really know how well I've done. I don't get any feedback. Quite often I don't even know if a case is settled. I've done my job and then I'm off, and I don't hear again. And he just said that, well, lawyers are particularly poor at communicating feedback. And they don't like to give each other a pat on the back. So if you're expecting a pat on the back as an expert witness, you're not going to get one. Oh my God, it was mortifying, a complete car crash. This was something that a lawyer said to me on an expert's performance at trial. Now, this is quite useful for highlighting the fact that you can be quite an experienced surveyor or expert witness, and this guy was a building surveyor. But if at most cases that you work on settle, you never actually are tested in the court. So when you do actually end up in court and you're not prepared for it because you've never done it before, but you think you're great because you've done an awful lot of expert reports, you could be in for a nasty shock. So this guy actually completely fell apart in the dock. He couldn't defend his evidence under cross-examination. And what happened there was that his barrister actually pulled his report, so his report couldn't be relied on in the proceedings. That's an absolute disaster and a complete waste of money. What another interesting fact from this quote was that this incident is still talked about. I still hear lawyers who weren't involved in the case at all talk about this. There's quite a strong grapevine amongst lawyers. They do talk about things like this. So, and a lot of my work really is through word of mouth and referrals. I don't know if this guy's ever worked again. I don't know if he'd want to be honest. But the fact that this is talked about still by people who weren't there at all shows that if you're not up to the job and you do make a mess of it, you might not end up getting any more similar work. I'm never doing that again. This was something my old boss said to me years ago. He was a very experienced consultant in his area, done a lot of expert witness work, really knew his stuff. But for whatever reason, he decided to take on an appointment that was in an area that he wasn't quite technically proficient in. So he ended up getting absolutely chopped to pieces by opposing counsel in the trial. And that was a horrible experience that probably still haunts his dreams. It highlights an important tactic, actually, that barristers will use, and something you shouldn't do. You should never take yourself out of your area of expertise, which is what my boss did. But it's a tactic that barristers might use when they're cross-examining you. They might try and pull you away from the area that you're competent in into an area that isn't your area really, and in doing so, they might trip you up. So the duties of an expert witness, the first one there, impartial duty to the court, that is the most important duty of an expert witness. You're impartial. Your duty is to the court. It doesn't matter that you're appointed by a client who has an interest in a certain outcome. Of course they have. You have to be impartial. Your duty is to the court. You also need to understand the legal process. You have some quite onerous legal obligations, the consequences of which can be quite severe, and I'll come on to that. The information you provide needs to be evidence-based, and I'll come on to what that means really in some examples of bad experts. You have an expert declaration to sign, a statement of truth, and you're bound by an oath or an affirmation. That's really important. You've got a legal obligation to tell the truth and to be honest. Now, I mentioned previously that a lot of failures of experts, of bad experts, is where they haven't really appreciated their duty. And an example of that is that I was on a case a while ago opposite someone I knew, and we were chatting at an event a long time afterwards. We were reflecting on the case, and this other consultant said something, and I said, "Well, hang on, but you said you didn't say that when you were in the box in the court." And he said, "Yeah, well, I was working to support my client's aims. That's what my client wanted." And that really shocked me, because essentially what he did was commit perjury. He lied under oath, and he clearly didn't understand the implications of that. That is a big deal. You might remember Chris Huhne, the Liberal Democrat MP, went to jail for committing perjury. He lied in court. That's what perjury is. So it's potentially a big deal. And if you don't understand that your legal duty to the court, you could end up in a bit of a pickle. So, expert evidence. So the style and the format of an expert report is very different to that of a standard technical report that you might produce. Firstly, I've labelled this the impartiality aspect. You need to be impartial. Your duty is to the court. There are nuanced and pronounced differences in how you produce an expert report, and the main thing there is that your opinions and the information you put into your report, your conclusions, your opinions, they must be based on fact. Now, those facts can be actual truths that you derive from the evidence that you've provided with, or from which you collect during a site survey, for instance, or they can be assumed facts from things like your experience. But there must be a clear, logical progression in the report showing how you formed your opinion. And that does make an expert report quite difficult to write. You can end up repeating phrases and having long sentences that you wouldn't put in a normal report, purely to make it abundantly clear the point you're making and how you've derived your opinion. They can be really, really tricky to write. There is some guidance on that sort of thing, which I'll come to later. So the general flow of the legal process, this is in a civil claim. That's really what we're talking about here mostly. So you'll see this is a general outline of how the process goes in a straightforward case. You'll note there's a number of steps, quite a few steps, and the case could be settled at any point along that chain. That means that the process can be quite lengthy. I mean, we're talking year or even years. Another issue associated with that is payment. How are you getting paid? That is a perennial issue with expert witness work, which you ought to go into with your eyes open. You can also settle it during the trial. That's happened to me before. So the general process is you get your instructions from your solicitor. That's where they tell you that they've identified the fact that they need an expert to provide an opinion on some technical issues related to the case. So you review all the documents, a bundle of documents, and it can be quite a lot of information for you to wade through. You then do a site survey, quite usually, to look at the situation, the technical issues. Then you produce your expert's report. You then swap reports with the other side's expert, review their report. You then meet together, and the point of that meeting of experts is to narrow down the issues to those that you disagree on. And if you do have some issues that disagree on, or you then produce a joint statement to show where you agree, where you disagree. And then on those issues where you disagree, that is why you go to court as an expert witness. That's why you're asked to go to court, to focus on and argue between the parties those issues where the two experts disagree, so the judge can then decide whose opinion he prefers, if you like. So the common mistakes of bad experts. So the first one is not being properly briefed. So the instructions you get from your solicitors, sometimes they're brilliant, they're really detailed. Other times they can be quite slapdash sometimes. In my experience, solicitors are often very busy. They are managing huge caseloads. So their eye's not on the ball sometimes, and they don't certainly have the time to guide experts as much as they might like, particularly if they're inexperienced. Similarly, as I've said before, that lawyers don't really give feedback or guidance. Barristers in particular are terrible at giving advice, and one of the reasons for that is that they must not coach or guide an expert witness. And I think almost to the point of terror of being accused of doing that they appear standoffish or unhelpful. So it's quite often that you're a bit worried that you might not get proper instructions, and if you don't recognise that, you can't ask for better instructions, and that's a common mistake of a bad expert. These next two bits, broad brush statements of you must avoid what a bad expert will do is use a broad brush statement or an unsupported generalization, and that leads to creating narratives without evidence. And what I mean by that is, so a broad statement might be a damp proofing expert might see some evidence and say, it's rising damp. That's a broad brush statement based on what? If you don't explain how you've arrived at that opinion, you're going to be chopped to pieces by opposing counsel. It might be that the rising damp caused by a faulty damp-proof membrane, but what if there's, say, a leaking pipe on the other side of the wall or something like that? It's often tempting, particularly for a technical person who knows their stuff, to use a broad brush statement and assume or fail to appreciate that the non-technical audience in the court, the judge and the lawyers, won't follow the logic that arrived at that conclusion. Another one that I've seen is to create a story, really create a narrative that without the evidence. If knotweed is growing in the countryside by a lay-by, and then an expert on the other side said, "Oh well, what's happened is somebody has come along and dumped garden rubbish, and that's what's caused the knotweed to grow there." Well, how have you arrived at that? What evidence was there that happened? That knotweed could have been growing there for a long time. It could have been a remnant of a larger area that was treated years ago. You can't. It's very easy to fall into that trap of saying a broad brush statement or making these generalized conclusions without properly going through the evidence. So that's a very common mistake. The next one, being ill prepared for oral evidence. So that really goes back to the quote I said earlier about the building surveyor who fell apart in the box. He was experienced expert witness. He had done a lot of casework. He had written lots of expert witness reports, but he'd never been to court. And it wasn't until he got into court that he realised he wasn't up to the job. That because you quite often don't end up in court, you can forget that that's part of the job. It's the end point of the job. It's really what you should be thinking about at the start of any work that you do in expert witness work. Arrogance, belligerence. If you're a technical person that knows your stuff, you can come across a bit arrogant, and if you don't understand and appreciate the environment of the court, that can count against you, and a barrister will certainly jump on that if they're cross-examining you. However, by far the most significant and probably the most common mistake that I see is a technical expert telling the client what they think the client wants to hear, not what the client needs to know. And the main problem I see arising from that is that a case will go all the way through to court, or at least it will be lodged, and money will be spent appointing experts, using the solicitor's time, getting a barrister involved potentially, based on flaky reasoning in the start. So I've seen a lot of cases where I've been called in to rescue them, where an inexperienced expert has said, yeah, you've got a case here, yeah, there's an issue here, there's knotweed is causing a problem, it's encroaching from another property. And then when I see the evidence, I say, oh my God, that's not clear at all. In which case, that whole case falls away. It's baseless. And I've seen that happen a lot of times. That's probably the biggest mistake that I see made by inexperienced experts. It's in the client's, it's in your interest as an expert to tell the client what they need to know. They need to know that they don't have a case. You can't tell them, yeah, I think you've got a case just because there's a little bit of evidence. It needs to be solid. And the outcome, there are some potential onerous outcomes from that. And the first one is here, a wasted costs order. So under the civil procedure rules, the court can issue a wasted costs order. So if as an expert you've caused the proceedings to continue beyond a point, or even to start at all, based on evidence that really is pretty flaky, then you could be smacked for costs, for the wasted costs in bringing that trial, bringing that action and through the court. Another one, your report can be made inadmissible, and that's just a waste of time completely. You might as well have not done any work at all. And if that was a key part of a case, well, then the whole case could fall away. And that's what happened in the incident with the surveyor who fell apart in the box I mentioned earlier. His report was withdrawn. His barrister said, right, okay, well, we can't rely on his evidence because he can't defend it. The whole report was pulled from the evidence, and the judge had no option but to rely solely on the other side's expert evidence. I mentioned perjury before. There's also contempt of court. So contempt of court is if you don't follow the rules of the court, and that could mean that you don't appreciate your duty to the court. And perjury is just outright lying. If you say something that's not true, and you know it's not true, then you've committed perjury, and you can go to jail for that. The last one, there's negligence claim. So if you produce a report for a client and you've been negligent as an expert for whatever reason, then the lawyers are quite within their rights to sue you for all their costs that they incurred in putting that case together. Now, I've seen this happen where an inexperienced expert has actually done a survey and has misidentified Japanese knotweed. So a whole case has been based on the fact that Japanese knotweed was present when it was actually another plant. So that case was lodged with the court. Fees were incurred in appointing experts and lawyers and a barrister, and it completely fell away because the expert got it wrong. There wasn't any knotweed there, so that case was baseless. So the solicitors were quite within their rights to make a claim. I actually don't know if they did, but I'd be surprised if they didn't. But they was quite within their rights to sue that expert for all those unnecessary costs. So I've got some examples, really. So I'm not mucking about. It really does happen. Experts really do get sanctioned for being bad, and there are a lot of bad experts out there. A lot of the cases, a lot of these examples, and a lot of the stuff that you might see in the news are to do with medical expert witnesses, because medical negligence litigation is a huge area. It's massive. So it's no surprise there's lots of mess ups there. These are all quite recent as well. So, you know, it happens a lot. Experts getting pulled up, so you need to be aware of that. This was a wasted cost order. So this was on a medical case, clinical negligence. The expert witness was punished by the judge for wasting the court's time, essentially. £89,000 was the value of the wasted cost order. In his judgment, the judge wrote that the expert was not generally competent as an expert and that he failed comprehensively in his duties to the court. So think about that. This went all the way to court, probably took a few years to get to that point. So in that long period of time, there would have been a lot of input from the expert witness, and no one noticed it until it got tested in the court. So you could be happily doing lots of expert witness work, thinking you're doing a great job, but it's when you're tested in the court, that's really when you know if you've done a good job or not. And if you've done a bad job, you could be smacked for something like a wasted costs order. This is another one from last year. Carbon credit fraud trial collapses as expert witness was no expert. So this was a £7 million fraud trial, and it cost millions in public money to put this through the courts. The judge ruled that the expert witness, who was working for the prosecution, so working for the government, prosecuting these fraudsters, the judge ruled that the expert was not an expert of suitable calibre. He had little or no understanding of the duties of an expert. He had received no training and attended no courses. He had no academic qualifications. His work has never been peer reviewed. So this guy had actually done a lot of work on other cases, and because this collapsed, because the judge found this guy to be not up to scratch, at least 20 previous other cases where there was a judgment were pulled up and picked over again, because if the prosecution was decided based on this expert's evidence, then that they could have been the rulings could have been overturned on those cases. So that's a huge implication for justice there, that the fact that this expert witness was found not to be up to the job, all the cases he'd worked on could have been challenged, so the criminals went free. And this is another one relatively recent. A dodgy doctor and law firm sentenced for fraud. This highlights an important issue, and it's the issue of the hired gun expert witness, which is a term you might come across. So a hired gun is an expert witness who is known to give the answer his clients want in his evidence. Really frowned upon, really bad practice. It's similar to another practice amongst some solicitors who might practice the dark arts of expert shopping. That's where a solicitor will go out to a number of experts and get reports or interview them and pick the one who produces the report or the answers that fits their needs. That's really seriously frowned upon. But what happened in this case was that this hired gun expert witness had produced 2 reports. He produced a draft report. He'd issued that to the solicitor. The solicitor had said, no, can you change it to this? So he did. And by a filing accident, a clerk at the law firm sent both the draft and the final report to the court. So the court saw that the expert had changed his mind, and they were sentenced for that. So that is a huge deal. So you really need to be aware of the fact that you can't be swayed by the whim of your client if they have an issue that they want you to address in their favour. If you can't, that is. This last one, this really is a bit of an extreme example. So this was a renowned psychiatrist who was struck off. This was an employment tribunal, so that might be why more severe sanctions weren't imposed. I'm not sure, to be honest. But she clearly lied, and she lied, and there's good evidence that she lied because the employee in the tribunal recorded her secretly on his phone. So you can't lie. She only got struck off. It could have been worse. You should bear in mind that your professional body, the PCA in our case, has a code of conduct, and if you fail to comply with that, follow that, you could be kicked out of the PCA as well if it's found that you've done something like this. But if you're in a court of law and you've lied, well, if that's perjury, then you could well be going to jail. So the approach to expert work. These 2 principles are my take-home pieces of advice, really. I think if you don't remember anything else from this webinar, these are the 2 most important principles, I think. If you're up to the job of being an expert witness, and if you adhere to these 2 principles, then you can't really go wrong. First of all, assume that you're going to end up in court giving oral evidence. If you worry about that right at the start, if you think, okay, if I write this, can I defend that if I'm in the box in court being challenged, attacked even by a very clever barrister? If you think like that, it should flavour the way that you write your technical report. And the other one, assume the opposing expert is as good as you. You might have been lucky. You might have done a lot of expert work against weak experts, and that might give you confidence that your arguments, the same arguments you use, can bulldoze through the next case. But if you come up against someone who knows their stuff, that might all completely fall away. So don't ever assume that, and because there are a lot of bad experts and experienced experts out there, don't assume that that's who you're going to be up against and your flaky argument will fly. Right, so Andy, you can jump in again.
Well, folks, I suppose just off the back of the webinar, I'm just going to throw out the question to you guys. I mean, after hearing what Paul has actually just had to say there, I mean, do you still feel like being an expert witness is right for you? There should be the poll that's just popped up in front of you on the screen. If you're on the desktop, it should be right in the middle. If you're on the mobile, you may need to kind of pull it up a little bit. Just going to hold it for about another 5 seconds or so. Interesting mix of answers coming back, Paul. Just give it another 3 seconds. 3, 2, 1. And I can tell you right now, a very much a mixed bag, Paul, with 28% saying count me in, 26% saying nay chance, and 44% saying unsure.
No, it's interesting. Okay, good. Well, I didn't put too many people off. That's good. Right, so what guidance is there then if you want to take up the mantle of being an expert? There are some training courses run by the PCA. The guy who I did my training course with is actually, which was 20 years ago, he is still doing courses, and he's brilliant. And he does the courses for the PCA. A guy called Lyndon Alexander. I actually met him on a course last year, and he's still doing an excellent job. Hadn't changed in 20 years. So check that out. I do recommend that you go on that course. The Civil Procedure Rules and Practice Direction, which I mentioned, part 35 is the bit for experts and assessors. Easy to read, tricky to apply, as much high-level government guidance is, I suppose. It's the base on which good expert evidence should be built. So you need to read that anyway. It's in your the declaration you make anyway, an expert's declaration, that you have read it and you understand it as part of you understanding your duty. There are a couple of professional bodies for experts as well. They've got a fair amount of guidance. There's the Academy for Experts and the Expert Witness Institute. There's also a lot of expert witness directories out there. Some good, many are bad. They are basically like the Yellow Pages. They'll take your money and put your name in. I don't know any lawyers who use them, to be honest. So, I wouldn't waste your money really. But it might be worth looking into. I think some experts in some areas do get work through that source. As I said before, the grapevine amongst lawyers is quite strong, so they talk to each other, and generally, if you're any good, your name will pop up in conversations. That's probably where most of my work comes from. You've also got these online referral services, which are a bit like directories, but they are more focused, because the way they work, they are looking for experts to fill their directory with, and then they will advertise their directory to solicitors, so that when you get an appointment through that referral service, the referral service takes a percentage. So it's in their interest to have decent people on their books, because they won't get any fees if they're not getting lots of work. So that's relatively new to me anyway, and it might be worth looking into. That's it. I don't think I've got anything more to say, other than if you've got any questions. Thanks for listening. I'll hand over to Andy.
Well, firstly, Paul, many thanks for that presentation. That was, well, I mean, certainly for a novice like myself, not a novice, certainly for a person that's not zero experience in this particular area. I mean, that was certainly an eye-opener to a certain degree, but I suppose I had the advantage of having a wee look into it before the webinar actually took place as well. Interesting quote as well that kind of came up earlier on when you were mentioning about the barrister is just someone that's very good at arguing. I can tell you right now, that job is written for my wife. When trying to win an argument with her is like trying to get blood out of a stone. Well, folks, we are nicely just on to question time now. So if you can just bear with me here, let me just bring up the questions. So we've got quite a few questions, folks. Just if you have a question that you maybe want to pose to Paul, now is the time to do it. Do you know what? I'm pleased to say we actually have quite a lot of questions here, Paul. I don't know how much we'll get through, but let's just batter on in and see how many we can kind of answer. So the first one's going to hit the ones that came via email to us prior to the webinar starting. First one comes from Stephen from Cardiff Council. Do you, now this, just to put it into context, this is actually more reflection with invasive weeds, and I think is covered stuff covered not covered in section 9, but he's asking, do you believe private nuisance claims will extend to other invasives like bamboo or Russian vine, or will the law relax and treat Japanese knotweed like brambles and ivy?
Oh, really a question for the lawyers, that. It's obviously, knotweed is a very specific property risk issue, but the law of private nuisance, as I understand it, can apply to pretty much anything. A lot of the case law that was used in some of these knotweed trials that have gone to court was based on tree roots. So yeah, there's potential, certainly. But if you're, but really, the law of tort, if you are causing a cost to somebody and it's not your fault, then it could be anything. So yeah, I think that's one for the lawyers, really. And I think that's an important thing as an expert witness. I always try and avoid getting into legal arguments, and I just do what I'm asked. And this is where, if you've got good instructions from a good solicitor, they've got very focused questions that they'll put to you, because they'll have a strategy, and they just want to know the answer to technical questions. And if you just focus on what you're good at, and answer honestly and truthfully and impartially, then you're not going to be dragged into an area that you're not so expert on. And I guess if you do start quoting law in your expert evidence, and you get it a bit wrong, opposing counsel could leap on you and cut you to pieces, make you feel uncomfortable in the box on that issue. So it's those sort of legal questions, something I try and avoid, to be honest.
No worries. We're moving on to our next question. Next question comes from Alison Stone. This is more a kind of general thing, and I'm sure you've come across this on the odd occasion, but she's asking, getting your client to understand your duty is no longer with them can be difficult. How do you deal with it, Paul?
So I'm not sure I understand that. What was that? Getting your...
Yeah, it's getting your client. If you're working for a client, but your duty is to the court, how do you make that client understand that your duty is no longer with them?
Oh, well, if there's not a lawyer between your client and you, then and they don't understand that, then you're in trouble. Yeah, obviously they've got your client wants an outcome. They want to win the trial. You just need to make it clear that you can argue what they're saying, but if it's a weak argument, they need to know, because if it's a weak argument, it's not going to fly. In which case, I have actually seen that happen before, where the barrister has been muttering, "For God's sake, settle! Why are you taking this to court?" That's kind of off the record, but I think a problem with some litigation is it's driven by emotion, and there's particularly neighbourhood disputes. There's an awful lot of emotion that can drive a claim to go all the way. If you think you're right and you hate your neighbour, that burning knot of hate in your belly isn't really the basis on which you should make a decision to lodge a claim against someone.
Yeah, no, I hear. And if anything, you're failing in your duty of care to your original client as well, before your duty of care and allegiances have to switch to the court itself.
Yeah.
So you're like, if you up to that point have been working for that client, then as the expert, your duty of care should be taking care of that person. I completely agree with you. Well, if you then kind of switch allegiances and you go into court and you've not given that duty of care and telling that person, like, listen, you're not going to win. It's just...
Yeah. Managing client expectations is another one of my tenets in consultancy that I'm always banging on to my staff. Manage expectations. Don't give the client bad news, and if you do, make sure you give it to them as soon as possible, and that you soften it as much as possible.
No, I've got you. Well, okay, moving on. Next question comes from David Burgess. Would it be a disadvantage in the court's eyes if you are an expert witness who is employed by a contracting company rather than being an independent surveyor?
It depends. Where a problem can arise is if it appears that you might have a vested interest in the outcome of the case. So an example there is if you've quoted or you're employed in doing contracting work, and then you're asked to become an expert witness in a dispute associated with that job, you've got a vested interest in the outcome, so you're getting paid to do the work. So as long as you don't have that concern of having a vested interest in the outcome, then you should be all right.
Okay. Well, the next question actually stems to reports. And again, this is a fairly generic question that goes over all sectors here. Question comes from Sam. Can you write a professional technical report that is totally correct from a technical point of view, but be negligent as an expert witness in court?
God, trying to think of an example. If it's technically true and honest, then you're probably all right. Yeah. Really, if the only way you might fail in your duty and being negligent is if you don't give a balanced view. I mean, that's one of the main things in an expert report, is that you need to show how you arrived at an opinion. If there's a number of alternatives, you need to lay them out and then highlight which one you prefer and why. So, yeah, if you do a good job, and it's technically sound, I can't see that you're going to be negligent unless you failed in your duty to the court some way.
So it's effectively explaining these are the paths that potentially it could have gone down, but in my expert opinion, I suspect it's this one.
Yeah, well, yeah, possibly. Yeah, but I think if it's technically sound, really, there isn't, in terms of that, the sort of technical content of a technical report and an expert report, there shouldn't be much difference. It's just how you present it, I suppose, in your expert report is different. And the language really and the style is something particularly difficult to get your head around in an expert report, because you need to make it abundantly clear. That sometimes means that you use funny English, almost really long sentences, repeating things so that it's absolutely clear who you're talking about. If it's, let's say, the defendant or an item, a technical item. So that they can be odd things to read, but the basic principle is that they should be absolutely clear. That you can't get double meaning from it because of bad punctuation, or you didn't want to use the same two words in the sentence.
Okay. Well, here, next question. Next question is a tricky one. I don't normally like asking questions about insurance, but I'm going to pose this one here. Now, there's actually, just to kind of let you know, Paul, here, there's actually been quite a few comments about PI insurance that have actually been coming through, but I'm going to frame it from what's been asked. And I suppose what I'm going to ask is, as an expert witness, is PI insurance essential? And would a normal PI policy cover all liabilities?
I don't know, but I'm pretty sure it is essential. I'm pretty sure it's essential. And I don't know if that is a requirement through the civil procedure rules, or whether it's something that a solicitor needs to check. But yeah, you're shaky ground. A solicitor wouldn't have done their due diligence properly if they're appointing an expert who hasn't got appropriate PI cover. With regard to limitations, I'm not sure, actually. There are exclusions for knotweed in some PI cover that limit the number of claims that you can make sometimes. But we've changed our PI cover recently from a provider we're with for a long time, and I know that some of the things have changed. But yeah, I don't know the specifics, to be honest.
Guys, just to kind of let you know, I know in the chat that some people were asking, do you know how much these policies are? I mean, that's really a case of a finger in the air. It's just like car insurance. You can't really predict what an insurance premium is going to be. But if you are interested, the PCA has two partners in terms of insurance, one being Astute and one being Canals. Feel free to kind of Google them, and you can hopefully maybe raise a question with them in terms of kind of costs. Just kind of moving on from the PI insurance, and again, I'm conscious of time here, Paul. So if you can try and make the answers kind of quick, just so we can try and rattle through some of the last questions. Les Hill raised an interesting point on the chat. He was mentioning that he encountered an issue at a joint experts meeting where the opposition tried bullying. How do you handle situations like this?
Yeah, another one for the experience, really. And I've come across that before. You've got to know what's right. And I have, I've stood up and said, hang on, this isn't right in such a situation before. And then you need to tell your solicitor as soon as possible. And if it's really off, you can actually tell the court. You can talk to the court and say things like that. But really, you should talk to your solicitors first. But yeah, I think that is something that comes with experience. If you know that something's not right, then you need to say something about it. But you might not know that it's not right if you've not done that sort of thing before.
Okay. Well, here, folks, I am very, very conscious of time. There is one or two questions that we've not maybe had a chance to ask. What I'll do is I'll ask Paul if he'll kindly maybe get back to individuals just with any kind of questions just back via email. I'm not going to make any promises, though, just on Paul's behalf. If he can get back to you, then Fabby, that would be great. Folks, just to kind of let you know, guidance and training, you heard Paul kind of mention it earlier on, some particular channels. I noticed on the chat as well, some people were asking where they could get some guidance. Well, if you are a PCA member, there is some training courses there that Paul alluded to. There is our writing expert reports training, which is ideal and a benefit to anyone that if you have a need in the future to act as an expert witness and prepare reports, it's ideal for you. But we also have another training course there, again, exclusively for PCA members, and it's a meeting of experts training, and this is like a workshop giving you kind of guidance and skills on how to kind of approach a meeting an expert. So with I suppose the foundation being to try and prepare you that if you were to go down the path of going to trial and being an expert witness, I won't go over just what Paul mentioned in terms of other kind of sources there of information, because he's kind of already gone over it, but it's up there on the screen if you are interested. And also just to let you know as well, there will be a replay of this webinar available from tomorrow for all. Just before we go, just to let you know, our next webinar is now up. It's on the 29th of October, and it's all about the Greenshold grant and the effects of shallow retrofit. We're hoping you can join us on the 29th of October. It's been led by PCA CEO Steve Hodgson. Web link is up there on the screen if you want to kind of register for it. It's just property-care.org/webinars. And on there as well, you will be able to kind of tune in and see any of our previous CPD webinars as well. Last but not least, I just want to say, firstly, Paul, big thanks from not only myself, but from everyone at the PCA for your presentation. It's been a pleasure having you on board, and certainly from ourselves, a big good luck to you in terms of future cases that you've got. Also, a big thanks to everyone that kind of tuned in to us today as well. We wouldn't be able to do this without your kind of participation and listening in. All it really leaves me to say is I hope everyone has a wonderful rest of the day, and hopefully we see you at the next CP webinar on the 29th of October. Goodbye, everyone.
Thanks. Bye.